So today we shall welcome and very warm evening to all the participants. We shall see here a very important subject, that is Uniform Civil Code. Family law is a compulsory subject in all LLB courses, and we shall see how this Uniform Civil Code Act 2024, which has been passed in Uttarakhand State Assembly, and it has been implemented and come into force since 27 January this year, 2025. So a lot of exercise was going into that, and it was considered that first the Uttarakhand state will implement it, and that model is likely to be implemented across India in different states. A high-powered committee was formed under the chairmanship of Honorable Justice Ranjana Prakash Desai, retired Supreme Court judge, and having members like Shatrughan Singh, our retired Chief Secretary and retired Chief Information Commissioner, and under his chairmanship, another committee was formed to draft the rules. So UCC rules were also drafted, and then this UCC came into effect. So we shall first see the features or the main highlights of this Uniform Civil Code of Uttarakhand Act 2024, and then we shall compare it community-wise with all the say major communities in India and how it compares with the say family laws of different communities and religions, and what are the changes and how it is going to affect different laws. So that we shall see one by one. First, we shall see that what is the Uniform Civil Code. Actually, there are different opinions about the name also, whether it should be Uniform Civil Code, because already we have Indian Contract Act, we also have traffic laws, we have Railways Act. These are also civil laws. So we already have Uniform Criminal Code in India. So instead of Uniform Civil Code, should it be called Uniform Family Code? Or whether we should call it secular civil code like called by the Prime Minister Narendra Modi. So is it a secular civil code? So let us see whether in spite of the nomenclature, whether you call it UCC, Uniform Family Code, or the secular civil code, let us see what are the fields within its scope. So it is a set of laws aimed at unifying personal laws across religions, covering areas such as marriage, divorce, inheritance, and adoption. Firstly, it doesn't affect religious practices, it doesn't affect cultural practices. So these two things are outside the scope. In these four areas, we shall compare it community-wise later, that is marriage, divorce, inheritance, and adoption, and how these are being affected. First, we see the significance of it in India. So it finds place in the Indian Constitution, that is Article 44 of the Indian Constitution. It encourages the state to implement a UCC to promote national unity and integrity. As we know, the rights were divided in two parts, that is the fundamental rights and directive principles of state policy, that is say DPSP, and DPSP are non-justiciable while fundamental rights are justiciable. That means we can go to court to get them implemented. Out of these some of the say directive principles of state policy have been converted into the laws, and Supreme Court has time and again directed the central government to enact uniform civil code. So we shall see its legal implications, religious implications, as well as the political implementations and stand of different political parties. That will be the say last part of this presentation. So first we see the background. So in February 2022, Chief Minister Pushkar Singh Dhami of Uttarakhand announced the intention to implement a UCC in Uttarakhand, and an expert committee was constituted on May 27, 2022 to draft the UCC. Now recently, as you might be aware, state of Gujarat has also formed another committee to implement it in the Gujarat. So that is going to be another state to implement UCC, and the same chairperson, that is Honorable Justice Ranjana Prakash Desai, is the chairman of this drafting committee for the UCC of Gujarat also, and maybe that would be followed by Madhya Pradesh, Uttar Pradesh, and it is expected that 18 BJP ruled states are likely to implement it within next 2 years. So let us see its legal and political implications. First, we see the development timeline. So on February 2nd, 2024, the committee submitted its detailed report to the state government. It's available. There is a separate website for that, and it's available in say uh, uh, Hindi as well as in English. Very long act is there, 392 sections and 7 schedules. And then the rules are also there, and these rules are submitted in 4 parts. These are also available on the UCC website of the Uttarakhand government. Then on February 8, 2024, the Uttarakhand Legislative Assembly passed the UCC bill. On March 8, the President of India granted assent to the act because it overlaps with and it also repeals some of the central acts insofar as they are inconsistent with or they are say overlapping with the central acts. So these become inapplicable to the state of Uttarakhand. Therefore, the governor can't take the decision, and as per the constitution, it was referred to the President of India. And then on January 27, the act was officially implemented in the state. And now there are some time-bound things that have to be done within 90 days. So there are various provisions that are there that would affect the say citizens, residents of Uttarakhand. First, we see what are the key provisions of the act. First is the marriage and divorce. So mandatory registration of all marriages within 60 days. That is after implementation of this. Even the older marriages have to be registered within 60 days, and online registration has been implemented, and there is a separate portal for this UCC within Uttarakhand. And from anywhere, people can register and do it online, just like in case of Election Commission of India voter registration. Then uniform grounds for divorce applicable to all communities. As we know, we have Section 13 of Hindu Marriage Act. We have different provisions in different communities. We shall compare this UCC with the different religious or say personal laws. Second is the inheritance and succession. So we have, of course, Indian Succession Act 1925. We also have, say, for marriage and divorce, in for Sikh community, we have Anand Marriage Act. There is Indian Divorce Act, say 1876 for Christian or Anglo-Indian marriages. So marriage and divorce, different acts are there. We also have inter-caste and inter-religious marriages in India. There is also Foreign Marriage Act 1954. For Hindu, we have Hindu Code Bill. 4 different acts are there. As far as inheritance and succession is there, so we had different laws in India. So equal inheritance right for sons and daughters. Again, it's different because Muslim women and Muslim daughters are going to be the biggest beneficiaries because their share in property will be immediately doubled after this coming into force of the UCC. So there cannot be discrimination among sons and daughters as far as inheritance rights are there. Standardized rules for succession irrespective of religion. Third is the live-in relationships. There is a separate part 4 for this, where there is live-in relationships. That is, registration is made compulsory. So there is mandatory registration of live-in relationships within 1 month, and legal recognition and protection of rights for partners and their children, because it's considered not as a violation of privacy, but when these couples get married and there are children, then there arises the problem of rights of those children also, and therefore some legal recognition had to be there, and therefore the live-in relationships, there is a separate part in this. Then prohibition of certain practices. So there is ban on polygamy and practices like halala and iddat that are there in Muslim personal law. So we shall see these also in detail. Then the applicability and exemptions. So what is covered? So all it's applicable to all residents of Uttarakhand, including those living outside the state. Secondly, exemptions. So scheduled tribes and certain protected communities are exempted to preserve their customary laws. Again, there are views in favor of this as well as against this. So we shall consider those also in the last part of this presentation. So for the time being, it's not been implemented across the scheduled tribes. Then implementation and support. So infrastructure is launch of an official portal for applications and registrations under the UCC framework. Again, there is some resistance of advocates and bar associations, and today some advocates are going on strike in Uttarakhand on Valentine's Day because they consider that their protest is mainly against 2 things. Firstly, against UCC. Secondly, against the online registry, because the registry is also going online in Uttarakhand now. Then support systems. So first is establishment of a help desk. There is a helpline for assistance and technical consultation as far as implementation is concerned. Secondly, availability of short videos and booklets for citizen awareness and officer training. So training programs have already been started. even before the implementation of Act, since the month of January, and then after brief training from January 27 January 2025, this Act has been come into effect, has been implemented. Now we come to the reactions and criticism. So support is that proponents use the UCC as a progressive step towards equality and national integration, because most of the countries have uniform civil code. India was an exception to that, and now it is coming into force in India also. Now let us see what the opposition has to say. So critics argue that it infringes on religious and cultural rights, particularly of minority communities. So we shall make one by one study of all the minority communities in India and how they are going to be say positively or negatively affected by this act. Then concerns about the potential impact on religious freedoms and homogenization of diverse traditions. So whether it is going to affect the religious or cultural practices or traditions, that also we shall see. There is PIL filed in Uttarakhand High Court, Nainital. No, it has not yet come in for hearing, and no adverse order, stay order has been passed, because Supreme Court itself has been time and again been suggesting to the central government that it should implement. So in implementation of this, the act has been passed, and even there were some reports of Law Commission of India. We shall see that. So we can conclude, as far as this Uttarakhand Act is there, that it is called as Uttarakhand Uniform Civil Code Act 2024. It represents a significant move towards unifying personal laws in the state. It aims to promote equality, fairness, and streamlined governance in civil matters, particularly the family law, because these are contested as per the Family Codes Act 1984 between family. Family is defined as people who are related by birth, marriage, or adoption. That is defined as family in the law. And then future implications are that implementation of the UCC in Uttarakhand may serve as a model for other states considering similar legislation. So it has already started in Gujarat, and maybe the MP and UP will soon follow, followed by other states in India. So we can say that this Act, Uttarakhand Uniform Civil Code UCC Act 2024, is the first state level legislation in India, that is after independence, because in Portuguese in Goa already UCC is there. So to introduce a uniform set of civil laws applicable to all residents irrespective of religion, there are only, say, 5 items that are considered in this. It standardizes laws related to marriage, divorce, inheritance, adoption, and live-in relationships. It doesn't affect religious practices, worship. It doesn't affect whether, say, dead bodies are burnt or, say, how they are disposed of. It doesn't affect that. So these things are outside the scope of the family law. To ensure gender equality and social justice. So we shall see how this gender equality and social justice is ensured. Now we see provisions in detail. Firstly, as far as marriage and divorce are there, so there is mandatory registration of marriages within 60 days, uniform divorce grounds. So we see that there are two types of couples: those who are married before the say coming into force of this act, and the marriages that would happen in future. So in future, registration will be compulsory within 60 days for the marriages that have already been existing since many years but have not been registered. So there are special provisions that are made on the portal, that is without going to the register of births and deaths or the register of marriages. People can directly register on portal, because there are separate laws for that. For birth and deaths there is separate register. For register of marriages there is separate register. So those traditional practices, traditional, say, mechanisms have now become online. Secondly, inheritance and succession. So equal property rights for sons and daughters for all communities, and that's why the people of different communities, particularly the Muslim communities, or we can say that all the Muslim daughters and say women, their rights have been directly doubled. Live-in relationships. So mandatory registration within 1 month after marriage and legal protection for partners and their children. There is ban on polygamy. So it prohibits multiple marriages. Bigamy is already an offense in India, 494 IPC. Even in Bharatiya Nyaya Sanhita BNS 2023, it is an offense because those provisions has been written as say as they were. And certain religious practices like halala and iddat. Halal is after divorce, the woman has to undergo compulsorily sex with another person, and only after that the woman is considered to be purified, and then the remarriage between with the old husband can be done. So that was a practice that is banned in this. Secondly, iddat. Iddat is the period whether first it test is made whether the woman gets pregnant after divorce, and if she is not pregnant within say 3 months, then after passing of iddat period, then that woman is free to get married with say another partner. In Muslim law, as we know, marriage is considered as a contract. In Hindu law, marriage is not considered as a contract. That is the main difference. Those who have studied Hindu law and Muslim law might already be aware of that. Exemptions are there. So scheduled tribes and certain communities retain their customary laws. So these are the important provisions. Now we see the detailed description of this. So Uttarakhand Uniform Civil Code UCC Act 2024 is a landmark legislation that establishes a unified set of personal laws governing marriage, divorce, inheritance, and related matters for all residents of Uttarakhand, irrespective of religion, gender, or caste. It was enacted on February 7, 2024 and receiving presidential assent on March 11, 2024. The Act came into force on January 27, 2025 and making Uttarakhand the first Indian state that is after independence to implement such a code. Now we consider these provisions in detail. First is monogamy enforcement. So as far as marriage and divorce are there, so the Act prohibits polygamy. That is, more than one marriages can't be done when that is person can't have more than one living spouse. Only after divorce or after death of the spouse, another marriage can be done. So Act prohibits polygamy and polyandry. That is, even a woman can't have more than one husband, more than one living husband, except in case of divorce, and allowing marriage only between individuals who do not have a living spouse at the time of marriage. So this monogamy enforcement is done like this. Secondly, the age of marriage. Time and again, Law Commission of India has stated that this age should be uniform. So it sets the minimum marriageable age at 21 for men and 18 for women, regardless of religion. Third, there is mandatory registration. So all marriages must be registered within 60 days of solemnization, and non-registration may result in a fine of up to rupees 10,000. There are some penal provisions also. We shall see that also. Now the grounds for divorce. Uh, uh, in Hindu Marriage Act, we have Section 9, that is for say restitution of conjugal relationship. And even a wife can file against husband, husband can file against wife. If that doesn't succeed, that is the restitution of conjugal relationship, then there is say judicial separation under Section 12. And if that doesn't succeed, then there is Section 13 under say this Hindu Marriage Act. So what are the grounds? So these grounds for divorce, it establishes uniform grounds for divorce, including adultery, cruelty. It is already defined in 85 and 86, 86 of Bharatiya Nyaya Sanhita. Earlier it was in 498A of IPC. So cruelty, then desertion, conversion to another religion, and mental disorder. So these uniform grounds have been defined. Then equal rights. So both spouses have equal rights to seek divorce, and the Act abolishes practices such as halala and iddat. So these practices have been abolished. Second, we see inheritance and succession, and what are the changes. Firstly, there are equal property rights. So it grants equal inheritance rights to sons and daughters, eliminating distinctions between ancestral and self-acquired property. This is very important because earlier there were different laws, whether it is an ancestral property or whether it is self-acquired property. So now there are no distinctions between ancestral as well as self-acquired property. This is very important change or significant shift from the earlier succession laws. Then there are two ways of dying. That is dying intestate, that is without testament or will or wasiyatnama, and another is testamentary, that is where a people writes wasiyatnama or how the property will be divided after his death or her death among the different and there are schedules in different acts like Hindu Marriage Act and how the property will be divided. So all these things are there in Hindu marriage. There's a Indian Succession Act as well as the personal laws of different communities. Second one is inclusivity. So it recognizes the rights of legitimate and illegitimate children. That is what we call as children born within wedlock and out of wedlock, jayaj or najayaj aulad. So it recognizes rights of both adopted children, dattak vidhi, say, and those born through surrogacy or assisted reproductive technology. So there are children through surrogacy, or even there could be say through assisted reproductive technology. So they also have been granted rights which were not there in the older laws. Then there are spousal rights. So it ensures that after the death of an individual, their spouse, children, and parents have equal rights to the deceased property. So these are the changes in mainly in the inheritance and succession laws. Next, we come to the live-in relationships, which is part 4 of this act. So registration requirement is there. It mandates the registration of live-in relationships. Failure to register within 1 month can lead to imprisonment of up to 6 months or a fine of rupees 25,000 or both. Secondly, the rights of partners and children have been protected. So it provides maintenance rights to partners. Earlier, we had, as you know, in criminal law, there is separate chapter on maintenance, that is 125, 126, 127, 128, which include the maintenance of wife or wives, present or past, and children and parents. So now these maintenance rights have been protected here. So it provides for maintenance rights to partners deserted in live-in relationship and ensures that children born from such relationships are considered legitimate with rights of inheritance and maintenance. Gujara Bhatta. Then additional provisions are there, that is custody of children, because these disputes often come to the courts. So in divorce or domestic disputes, it grants custody of children up to 5 years of age to the mother. So up to 5 years, woman always gets this custody. Secondly, will and testament. As I told you, there are two different ways of dying. That is dying intestate, that is without writing testament. वसीयतनामा लिखकर मरना और वसीयतनामा लिखे बिना मर जाना. So these are the two ways. So we considered as dying testamentary and dying intestate. So will and testament is there. So it establishes a streamlined framework for the creation and cancellation of wills and supplementary documents known as codicils, testamentary succession. So codicil is there, that is testamentary succession, where a person writes will or wasiyatnama, and after wasiyatnama the person dies. So for that, this provision is there. Then we see that there is provision or some exceptions that have been provided in this. So let us see what are the exemptions. The exemption is that the Act does not apply to members of scheduled tribes and certain protected groups, allowing them to continue following their customary laws in personal matters. So they have been exempted from the say enforcement of these laws. Now, to facilitate the implementation of the UCC, the Uttarakhand government has developed an online portal and mobile application. Mobile app is also there, enabling residents to register marriages, live in relationships, and access related services digitally. And officials have been trained to ensure effective enforcement of the Act's provisions. Now we see what is the significance of that. So Uttarakhand UCC at 2024, it represents a significant move towards legal uniformity and gender equality in personal laws within the state. By standardizing laws related to marriage, divorce, and inheritance, the Act aims to promote social harmony and protects the rights of individuals, particularly women and children. The pioneering legislation may serve as a model for other Indian states considering the adoption of a uniform civil code. Now we see it's a comprehensive legislation aimed at unifying personal laws. How it unifies? So now we shall compare one by one with different communities, and we shall see how they are going to be affected. So it relates to marriage, divorce, inheritance, and living relationships for all residents of Uttarakhand, irrespective of religion, gender, or caste. It is enacted on February 7, 2024 and came into force on January 27, 2025. And Uttarakhand became the first Indian state, that is after Goa. Goa was implemented in under the Portuguese Uniform Civil Code to implement such a code, and it became independent and merged in India in 1961. And earlier it was Union Territory, then it became a state of India. So Act applies to all individuals residing in Uttarakhand, including those living outside the state, except members of scheduled tribes and persons whose customary rights are protected under Part 21 of the Constitution. So when we see that there is a provision in Constitution and their rights have already been protected, because there are many scheduled tribes in northeast India also, and therefore they have been outside the purview of this UCC. That is, say communities that have been STs and other communities that are protected under Part 21 of the Constitution. Then we see marriage. So the Act prohibits polygamy, polyandry, allowing marriage only between individuals who do not have a living spouse at the time of marriage. In service laws also, in conduct rules, there is provision in many state government rules that they have to give a declaration that they don't have more than one living spouse at the time of entry into government service. So for government service, it was already present, but now it applies to all citizens. That is a major change. Age of marriage. So it sets the minimum marriageable age of 21 for men and 18 for women. Mandatory registration. So all marriages must be registered within 60 days of solemnization. Now registration may result in a fine of up to rupees 10,000. So we see there are two penal provisions. For marriages, it is 10,000. For live-in relationship, it is 25,000 if it is not registered within the deadline. Then ceremonial flexibility. Now, when we come to ceremony, then ceremony, solemnization, and many different concepts are there in different family laws. So marriages can be solemnized according to religious customs or legal provisions, but registration remains compulsory. That means there is no bar on religious or cultural practices, and they can perform by whatever customs or traditions they want to perform their marriages. So these ceremonial flexibility is there. That means it doesn't affect the religious or the cultural or the traditional practices. Secondly, we come to divorce. So there are uniform grounds. It establishes uniform grounds for divorce applicable to all communities, addressing issues such as cruelty, adultery, desertion, and mental illness. Equal rights are there. We shall compare this with different community laws. Then both spouses have equal rights to seek divorce, and the act abolishes practices such as halala and iddat. Then equal property rights are there. So it grants equal inheritance rights to sons and daughters, eliminating the distinction between ancestral and self-acquired property. Uniform succession rules are there. As we see under this Act, some rules have also been enacted. They are also available on the website of Uttarakhand UCC portal. So establishes a uniform set of rules for inheritance based on the relationship to the deceased, irrespective of religious affiliation. So these have been drafted by the Shatrughan Singh committee. Now we come to the last part, that is live-in relationships. So mandatory registration is there. So partners in live-in relationships are required to register their union within the with the designated authorities. Non-registration can lead to penalties, including imprisonment of up to 6 months and fines up to rupees 25,000. Legal recognition is there. That is, children have born from registered live-in relationships are considered legitimate with rights to inheritance and maintenance. So both these rights have been given to children. That is, they can inherit the property and they can maintain. They can get maintenance in case of separation of their parents uh, if the live-in relationship was registered. Then there are maintenance rights. So it provides provisions for maintenance of partners resulted in live-in relationships, ensuring their financial security, so that it doesn't result into say bitter disputes like in family courts or in say criminal disputes. Now there are prohibited practices that are there. So, firstly, explicitly it bans the practices of polygamy and polyandry across all communities. Child marriage, we already have in India Child Marriage Restraint Act also. So it reinforces the prohibition of child marriages, aligning with national laws. So that they are consistent with our central laws. Then nikah halala. So it criminalizes the practice of nikah halala, which with penalties including imprisonment up to 3 years and fines up to rupees 1 lakh. Also, we have laws banning the three talaq. That is, we shall consider this Shah Banu case and of 1987. There is one law. Another law was enacted in 2019. So we shall compare with that law also. Now the penalties are there. So for false information, providing false information for marriage or live-in relationship registration can result in imprisonment of up to 3 months and fines up to rupees 25,000. Unlawful dissolution, just like we say teen talaq or like that. So dissolving a marriage without a court order is punishable for imprisonment up to 3 years. So this is in line or consistent with the existing three talaq laws. Then exemptions. So scheduled tribes, it exempts member of ST from its provisions, allowing them to continue following their customary laws in personal matters. So it is considered progressive legal reform. That is seen as progressive legal reform, but has sparked debate over its implications on religious freedoms and cultural practices. Uttarakhand UCC is expected to serve as a model for other states considering similar legislation. Implementation of the Uttarakhand UCC Act 2024 marks a significant step towards legal uniformity in personal laws within the state, promoting equality and social justice across diverse communities. So these are references. UCC of Uttarakhand Bill 2024. Now it has been passed into Act. There is UCC Uttarakhand official portal. There was a Hindustan Times article how uniform civil code will work in Uttarakhand. Live law article is there. Uttarakhand rolls out uniform civil code, becomes first state to do so. There is DD news article. Uttarakhand becomes first state to implement uniform civil code. And then we come to another presentation where we are comparing it with the existing religious laws or the personal laws. So we shall see one by one how why it is in news. So firstly, an expert committee headed by retired Supreme Court judge, as I told, Justice Ranjana Prakash Desai, has been constituted by Uttarakhand to implement UCC and for checking say all the relevant laws that control personal matters for those living in Uttarakhand. So we shall go into working of this and what is there in the 4 reports that are published on the website. Few months ago, the Allahabad High Court also called upon the central government to initiate the process for implementation of UCC. Then we shall consider judgments of Supreme Court and the reports of the Law Commission of India. So UCC would provide one law for the entire nation, including all religious communities in their personal matters such as marriage, divorce, inheritance, adoption, etc. Article 44 of the Constitution lays down that the state shall endeavor to secure a UCC for the citizens throughout the Indian territory. Article 4 is one of the directive principles of state policy, that is DPSP. There is another article, that is Article 37. It says that this DPSP are not justiciable, that is not enforceable by any court. However, the principle laid down therein are fundamental in governance. Now we see the status. So firstly, in most civil matters, India already has the UCC. So Indian Contract Act is there, 1872, from which say there are other laws like Sale of Goods at 1930. There is also Indian Partnership at 1932. There is also Specific Relief at 1963. We have Civil Procedure Code, that is uniform, 1908. Transfer of Property at 1882. Partnership at 1932. Evidence at 1872. So already we have UCC in India. Only Uniform Family Code was not there. So that's why some people say that it should be Uniform Family Code, or rather it should be called as Secular Civil Code. In certain matters, however, there is diversity even under the civil laws, as states have made hundreds of amendments to these, because some come in the concurrent list as per 7th schedule of the Constitution. Several states refuse to be governed by the Uniform Motor Vehicles Act 2019. And at present, Goa is the only Indian state that has implemented UCC. So Goa already has this law in Portuguese Uniform Civil Code is there. Then we see that how it originated in British India. So now we are going into history of it. So UCC's origin dates back to British India when a report was submitted in 1835. This report states that is this was started in 1835-1836 when Lord Macaulay was there, when they were working on uniform criminal law for India. So the report, this report states on the need for uniformity in the codification of Indian law relating to crimes, evidence, and contracts, specifically recommending that personal laws of Hindus and Muslims be kept outside such codification. Legislation dealing with personal issues increased. This forced the government to form the B.N. Rao Committee to codify Hindu law in 1941. So this B.N. Rao Committee was formed. Now there is Hindu Succession Act 1956. So we are already aware of the 4 laws of that are applicable to Hindu community, what we call as Hindu Code Bill. So based on B.N. Rao Committee's recommendation, the Hindu Succession Act 1956 was adopted to amend and codify the law related to intestate. This I have said, the word is not interstate. Remember, it is intestate, that is dying without writing testament. Wasiyatnama ya will likhe bina mar jana. That is called dying intestate. So that is called relating to intestate or unwilled succession. Will is Vasiyatnama. And among Hindus, Buddhists, Jains, and Sikhs, that is, Buddhists, Jains, and Sikhs were considered as part of Hindus. So Hindu Code Bill or Hindu Succession Act applies to these 4 religious communities, that is Hindus, Buddhists, Jains, and Sikhs. However, there were separate personal laws for Muslims, Christians, and Parsis that were outside the purview of this. So we shall consider community by community how this compares. Now we come to the SC judgments. So in order to bring uniformity, the courts have often said in their judgments that the government should move towards a UCC. Judgment in the Shah Bano case, 1985, is well known. Another case was the Sarla Mudgal case, 1995. We draft the issue of bigamy and conflict between the personal laws existing on matters of marriage. Particularly when we talk about intercaste or interreligious or say people have marriage having with people having different national citizenship. So these often come into conflict. Then Supreme Court judgment in Shaira Bano case, that is 2017, had declared the practice of triple talaq, that is talaq-e-biddat, as unconstitutional. And then the government had enacted a law. So by arguing that practices such as triple talaq and polygamy adversely affect the right of a woman to a life of dignity, because Supreme Court is considered it under Article 21. The center has raised the question whether constitutional protection given to religious practices should extend even to those that are not in compliance with fundamental rights. That is, when there is conflict between fundamental rights and DPSP, then what should be done? That was the question. So what is the need of UCC? So all citizens must be treated as equals, and government sponsorship or regulation of religious places or events must be placed in the constitution. Secondly, the enforcement of UCC would help narrow down the religious divide in a country like India, and it would result into undivided community, that in a country like India where people of different religions reside. So there should be inclusivity, as well as protection. The enforcement of UCC would provide protection to vulnerable sections, that is, we call women and children mainly, simplify laws and ensure gender justice, adhering to the ideal of secularism. And that's why some people also call it secular civil code. Now, what are the challenges to adoption? So let us consider it. Firstly, the first allegation against this is it is against Indian concept of secularism. That is, it is feared by many that by attempting to implement UCC, the parliament is only duplicating the Western model of law, which is based on uniformity. But Indian concept of secularism is based on diversity of religions and people. So whether it is in conflict with this diversity, in India, people are having different religious faiths. That is, diverse religious practices make it to implement a basic platform of practices for every religion. Then minorities, that is Muslims, Sikhs, Christians, Buddhists, Jain, and Zoroastrians, Parsis, have a misconception that UCC will destroy their religious practices and they will be compliant to follow the religious practice of majorities. Then unawareness of people. So the most significant issue is unawareness of people regarding the objects of UCC, and the reason for such unawareness is the lack of education, fake news, irrational religious beliefs, etc. Then there is communal politics. So the demand for uniform civil code has been framed in the context of communal politics. A large section of society sees it as majoritarianism under the garb of social reform. That is another allegation. Then constitutional hurdle, that is Article 25, which protects religious practices. So Article 25 of religious freedom. Article 25 of Indian Constitution that seeks to preserve the freedom to practice and propagate any religion gets into conflict with the concepts of equality enshrined under Article 14 of Indian Constitution. So whether this 25 is in conflict with 14, that is the question. Now the way forward for this is the government and society will have to work hard to build trust, but more importantly, make common cause with social reformers rather than religious conservatives. And rather than an omnibus approach, the government could bring separate aspects such as marriage, uh, divorce, adoption, succession, and maintenance into a UCC in stages. And need of the hour is the codification of all personal laws so that prejudices and stereotypes in every one of them would come to light and can be tested in the on the anvil of fundamental rights of the Constitution. Now, firstly, how UCC could impact marriages. So on April 22, Union Home Minister Amit Shah, while addressing a BJP meeting in Bhopal, reportedly told his colleagues that it was time to focus on the Uniform Civil Code UCC. Almost on cue the next day, Uttar Pradesh Deputy Chief Minister Keshav Prasad Maurya said that BJP government in the state was considering implementing the UCC. Then in next door, Uttarakhand, the BJP state cabinet is already joining committee of experts for the same. Then Shah's intent seems clear. Uttarakhand is a pilot project for what will say have a national footprint, and it is being seen like that. Now we see what was the BJP manifesto and B.R. Ambedkar. So the UCC has been part of the BJP manifesto since 1998. And nearly 2 decades later, the Saffron Party seems to be inching towards implementing the contentious agenda. Having a common set of laws governing marriage, divorce, adoption, and succession for all Indians, irrespective of religion, equally essentially one civil law applicable to all citizens, is an ideal mentioned in the directive principles and was seen as a desirable norm by Dr. B.R. Ambedkar, the architect of the Constitution, though he felt that the new republic was not ready for it at that time. So now the question is it now ready after 75 years? So let us see that. The Supreme Court has occasionally answered in the affirmative. In its Shah Bano verdict in 1985, in 2015, as it spoke for the total confusion in civil laws across religions, and in 2019. In February, it also transferred cases on the UCC in various high courts to itself and tagged all of them for final adjudication. Now the Law Commission of India, what were the reports submitted by it on this? So in August 2018, the Law Commission had struck a different note. So, though saying that UCC was neither necessary nor desirable at this stage. This was in a paper on reform of family law prepared after the Union Ministry of Law and Justice asked it in 2016 to examine the issue. The paper wanted discrimination against women within communities removed rather than looking for equality between communities in terms of family law. And the final report is awaited. Then Union Law Minister Kiran Rijiju says that when it is out, the center will start consultations within, with all the stakeholders. Then, since Justice B.S. Chauhan retired as chairperson, that is chairperson of Law Commission of India in 2018, no appointment has been made to the Law Commission. The center clearly is treading cautiously because he had recommended that it is not right time to implement UCC in India. Now, can a state frame its own UCC? That is, we now consider the federalism or whether it affects the concept of federal India. So, well, subjects such as marriage, divorce, adoption, and succession are in concurrent list. That means both the center and the states can legislate on them as per the 7th schedule to the Constitution. Now, does that include the power to frame a UCC? So, Constitution expert and former Lok Sabha Secretary General PDT Achari believes so, while former Union Law Secretary PK Malhotra feels that only Parliament is competent to make such a law, since Article 44, the relevant directive principle, refers to all citizens across India. Then Uttarakhand has a precedent though. Goa already has a common civil code, a remnant of the Portuguese civil code of 1867. So not a uniform law in the true sense. It allows bigamy for Hindus in specific circumstances. That is when there is a failure to beget children. The code also, and there is consent of previous spouse, previous wife. The code also allows the church to both sanction and annul marriages, and is disingenuous in many ways because it is based on the Portuguese law. The right to freedom of religion, that is, now we compare, does it conflict with 25 and 26? So meanwhile, many argue that UCC violates the freedom of religion under Articles 25 and 26. So India is a multi-faith country, and every citizen is guaranteed to practice and profess their faith and religious beliefs and to act on and preach the same. So said the Muslim Personal Law Board in November 2021. Then the AC, however, observed that UCC doesn't impinge on the right to religion. So that was observation of the Supreme Court of India. Now there is no single draft. So another problem with the UCC is that there is no single draft on it. Two bills were passed earlier, presented earlier in Parliament also, but they were withdrawn. So nobody knows what shape it will take. But now we have got this model of Uttarakhand. So what provisions it will cover and how it will affect the existing laws of various communities. So many suspect, and more so because the BJP and RSS have been betting for it, that the UCC will scrap the personal laws of minority communities in favor of majoritarianism Hindu laws. So we shall see how it affects communities one by one. First, we study Hindu laws. So UCC will impact Hindu laws as well. For example, Section 2.2 of the Hindu Marriage Act says that its provision will not apply to the scheduled tribes. And we see that in Uttarakhand, scheduled tribes have been kept outside purview of this act. Then we come to sections 5.5, section 5, subsection 5, and section 7 of the law state that customary practices will override the provisions, while the UCC won't allow for such exceptions. Then there is overlapping with criminal laws because we already have 125, 126, 127, and 128 of CRPC. They are there in BNSS also. So the coexistence of personal laws with several criminal laws also adds to the confusion. For example, section 125 of the CRPC to provide for the maintenance for wife, children, and parents, and penal laws for protection against dowry. We already have this Dowry Prohibition Act 1961, and there are rules of 1995, and domestic violence, for which we have DV Act 2005, also overlap the scope of personal laws. So there are criminal laws. Now there is Muslim dependence on Hindu personal laws. So a large section of population, including Muslims, has already taken recourse to the various sections of the law to resolve civil disputes. So dependence on religious personal laws is gradually dwindling. While debates continue over the sagacity of a UCC, here is a cursory glance over the various personal laws in India and how the UCC may impact them. First, we see impact of UCC on marriages. So common law can fix minimum legal age for marriage. We see it is 21 and 18. Abolish bigamy and polygamy. We have seen in Uttarakhand, they have abolished polyandry also, and encourage interfaith marriages. We have Special Marriage Act in India 1954. We also have Foreign Marriage Act in India. That is where marriages are between Indians but celebrated outside, India. That is foreign marriage. So marriage with foreigner is covered under Special Marriage Act, while marriages celebrated in foreign countries come under Foreign Marriage Act. So we have those two acts also. Now, marriage law for Hindus, Buddhists, and Jains. So marriages in the three religions are governed by the Hindu Marriage Act, HMA 1955. Now, special provisions the UCC may abolish. Firstly, Section 2.2 of the Hindu Marriage Act, which excludes scheduled tribes from the applicability of the law. Sections 5, 5, and 7, which allow customary practices to override the provisions of the law. So we have seen already provisions has been made in UCC Act of 2024 in Uttarakhand. Then marriage law for Muslims. So the Muslim Personal Shariat Application Act 1937 states that Shariat or the Islamic law will guide marriage, divorce, and maintenance. So special provisions that the UCC may abolish. How it will affect the Muslims? Firstly, minimum age of marriage under Shariat, which is 15 years or puberty. So now that 15 years has been raised to 18 years. For men, it is 21. Then man having up to 4 wives, provided they treat all of them equally. Now it has resulted into monogamy. Then marriage between a Muslim man and a non-Muslim woman, which is not considered void but irregular. and can be validated if the woman converts to Islam. So there was this compulsory conversion to Islam that was there in the Sharia Act. Now that won't happen because this 1937 would be inconsistent and that will not be applicable in case of UCC. Then governed by Indian Christian marriage, there is how it will affect the Christians. So it is governed by Indian Christian Marriage Act 1872. There is also Indian Divorce Act 1876. This special provisions the UCC may abolish, that is intercaste or Indian religious marriage between a Christian and another person being invalid, because there is Anglo-Indian community, that is where British people married Indian people. So intercaste or interreligious marriage between a Christian and another person being invalid if the personal law governing the other person prohibits marriage with a Christian. Then marriage full law for Sikhs. We already have Anand Marriage Act in India for that, 1909. So all marriages are solemnized according to the Sikh marriage ceremony called Anand, commonly called as Anand Karaj, and are governed by Anand Marriage Act 1909 and Anand Marriage Amendment Act 2012. So special provisions that the UCC may abolish are marriages registered under the Anand Act not being registered otherwise. So now for Anand Act also, that is for Sikh community also, registration has become compulsory. How it affects the Parsis? So marriage law for Parsis. So marriages among Parsis are governed by Parsi Marriage and Divorce Act 1936. So special provisions that it abolishes: women losing all rights to Parsi rituals and customs if they marry someone practicing other religious faiths. That was there. That is, if they marry outside Parsi community, then they lose all the rights and all the rights and customs that was there in the Parsi law. So that will not be implemented now because that is in conflict with UCC. Now, how UCC can affect divorce? So the constitutional objective of Uniform Civil Code is to frame religious neutral common laws on marriage, divorce and inheritance for all Indians. With triple talaq now illegal, existing personal laws of all religions offer enough protection to women. So Uniform Civil Code may codify these to avoid overlap and misinterpretation. So we take a look at the divorce laws for different religions. So we shall compare it religion by religion. First, we see how it affects the Hindus. So, under the Hindu Marriage Act 1955, the husband or wife can seek divorce on 9 grounds. There are 4 additional grounds available to the wife. Now, there are common grounds under the UCC of Uttarakhand as we see. So, both husband and wife are legally entitled to claim alimony and maintenance. The wife can also claim maintenance under Section 18 of the Hindu Adoptions and Maintenance Act 1956. Now, we see how it affects divorce laws for Muslims. So, under Islamic law, divorce is classified into 3 categories: talaq, or divorce at the instance of the husband; khula, or divorce at the instance of the wife; and mubarat, that is divorce by mutual consent. So the husband can delegate the power to pronounce talaq to the wife to any third person by an agreement. That is, delegation of powers is there in Muslims. The Muslim Woman Protection of Rights on Marriage Act 2019, what we call as Triple Talaq Act. So this has made talaq by the husband an illegal and punishable offense. Same punishment is prescribed in UCC of Uttarakhand also we see. So if a Muslim husband now wants a divorce, he must get the talaq validated before a family court. So Muslim women have a legal recourse apart from traditional modes of separation. The Dissolution of Muslim Marriages Act 1939 sets out 9 grounds on which a Muslim woman can seek dissolution of marriage. So according to Sharia, Muslim women are given absolute right to alimony and maintenance, and the right remains unprejudiced even if the wife has good financial standing and the husband is poor. So now that is going to change for Muslims. How it affects Christians? So we have Indian Divorce Act 1869. So divorce among Christians is governed by the Indian Divorce Act 1869. The husband-wife can seek divorce on 9 grounds. The wife can seek divorce if the husband commits rape, sodomy, or bestiality, that is, sex with animals. Only a wife can claim maintenance and alimony. Husband can't claim alimony, maintenance and alimony among Christians. How it affects divorce law for Sikhs? So Anand Marriage Amendment Act 2012 is silent on provisions of divorce because it is assumed that laws of Hindus will be applicable on Sikhs also. So there is no separate provision. How it affects the Parsis? So there are 10 grounds for divorce and either spouse may seek it under the Parsi Marriage and Divorce Act 1936. That said, only a wife has the right to claim maintenance and alimony, not the husband. So now gender equality is there in case of UCC. Now, how UCC could change inheritance laws? First, we have seen marriage laws, then we have seen divorce laws. Now we are coming to inheritance laws, religion by religion. So the constitutional directive of a UCC is to frame religion-neutral common laws on marriage, divorce, and inheritance for all Indian citizens. So Muslim and Parsi daughters still do not have the equal right to inheritance. So Uniform Civil Code may change that. So now we have seen that the this share of Muslim and Parsi daughters or say women has been doubled or increased. It may also grant the right to children born out of wedlock, what we call as najayaj aulad. that is children born out of wedlock. While the debate over uniform civil code rages, we meanwhile examine the various inheritance law across religions. So now we do this comparison. Firstly, how it affects the succession laws for Hindus. So there is Hindu Succession Act 1956. It allows the provision to write a will, wasiyatnama. In case of a legally adopted accepted will, laws of inheritance don't apply because it overrides. We have seen there are two ways of dying: dying after writing a will and dying intestate, that is without writing a will. वसीयतनामा लिखकर मरना, वसीयतनामा लिखे बिना मर जाना. In the absence of a will, property can devolve through the law of inheritance. So there is a schedule that gives the percentage of different say relationships. Then daughters have right to equal share as sons in the property, and this is there in UCC also, as we have seen. The Act makes a distinction between ancestral property and self-acquired property. That was there in Hindus, and now there will be no distinction in UCC, as we have seen. Any undivided property that passes to descendants up to 4 generations of male lineage is called ancestral property. A grandchild has a birthright to ancestral property but has none over self-acquired property of grandparent. Now that is going to change for Hindus. Child born of a voidable marriage out of wedlock is a legitimate heir, and the Act doesn't apply to those married under Special Marriage Act 1954 unless both spouses are Hindus, Jains, Sikhs, or Buddhists. Because we have seen the Special Marriage Act applies to intercaste or inter-religious marriages in India, and succession in these cases is governed by the Indian Succession Act 1925. That is applicable if they are of different religion. How it is going to affect the Muslims? So according to Muslim Personal Law Shariat Application Act 1937, Muslim man may bequeath only 1/3 of his assets by will, provided the heir's consent is obtained. So the spouse and other heirs inherit the remaining estate, and an heir cannot inherit the property if it does not pay the debts inherited from the deceased. So he's liable for the liabilities also. He has to pay all the debts inherited from the deceased person or the ancestor. Then the share of a female heir is half that of the male heirs. Now that's how the share of Muslim women and Muslim daughters is going to be doubled in UCC. A Muslim woman is entitled to an eighth of the husband's property share if there are kids, else a quarter. So again, that is going to increase in case of Muslim women. Muslim laws don't recognize children born out of wedlock. The Act doesn't apply to those married under Special Marriage Act 1954. Succession in such cases follows Indian Succession Act 1925. That is interreligious marriages. Then succession laws for Christians. So succession is governed by Indian Succession Act 1925. It allows a will bequeathing all or part of properties and share of the children equally distributed across among sons and daughters. And Christian law does not recognize children born out of wedlock. Now, succession laws for Christians. So a Christian wife is entitled to a predetermined share, that is at the time of marriage. If the deceased has left children, his widow receives 1/3 of the estate, with the rest going to the children. And if the heirs are relatives other than the children, then she gets half of the estate, and the remainder goes to the other relatives of the deceased. So that percentage is there. If there are no children of or other relatives, then she receives the entire property. That is at present the law for Christians in India. Now we compare it how it affects the Parsis. So succession is governed by the Indian Succession Act 1925. If a Parsi man dies leaving a wife and children, the share of each son and of the wife shall be double the share of each daughter. If he again in Parsis we see the share of women is going to increase in case of UCC. If he dies leaving children but no wife, the share of each son shall be double the share of each daughter. So obviously Parsi daughters will be beneficiaries in UCC. However, if a Parsi woman dies leaving her husband and children, then each child and husband will receive equal share. Now, if a Parsi man dies leaving one or both parents in addition to children and wife, the father will receive a share equal to half the share of a son, and the mother will receive a share equal to half the share of a daughter. If a Parsi woman dies leaving behind one or both parents along with children and husband, the parent or uh, both the parents will receive a share equal to half the share of each child. So again, we see that in Parsis, say women get less share. In case of UCC, their share will be more. So that is how it is going to affect these communities. So we can say that these different communities' laws are going to be affected. And now I think I have already taken 1 hour. So if there are questions, then we can go to these questions one by one.
Thank you so much, sir, for providing us an overview. Participants, in case you all have any queries, do use the raise hand function. We'll unmute you, or you can raise your queries in the chat box. So there's a query. What is the current law on inheritance with regards to ancestral property now?
Okay, under the for Hindus, I have already stated that in the say the children don't have a right over the self-acquired property. They only have the right over the ancestral property up to four generations. That is the law for Hindus. But now under the UCC, that is going to change because it makes no difference between the inherited ancestral property and the self-acquired property. So ancestral is born through efforts of say grandparents or say forefathers, while the self-acquired property is property earned by a person through his own efforts. So that is how these properties are defined. So Hindus are obviously going to be affected in the case of inheritance because UCC makes no distinction between these two types of say laws.
What is
Yes.
the minimum age for marriage?
Well, earlier it was different for different communities. Under UCC, it is 21 for male and it is 18 for say female. And Law Commission of India has time and again on various reports. They are already there on the Law Commission of India websites. So you can go through those reports. They have recommended that this definition of child, definition of minor and major, that is what is the age of majority in different civil laws and criminal laws and even under say what we call as child marriage abolition act, even say uh, different laws relating to say rape, that is under the chapter 5 of the Bharatiya Nyaya Sanhita. It has now provided this different age. Earlier there were some in some cases 15 years, 16 years, 18 years, age of puberty. So all this was creating a lot of confusion, and even it was affecting this JJ Act. You are under Juvenile Justice Act also definition of child is there. So now all that is going to change because there is going to be uniform age for all the communities, and therefore this age will be 21 and 18. So for voting, the age is 18. I mean, it is easier to run the country than say getting married and say having a spouse. So for getting married, the age is 21. For voting right, it is 18 in India.
Yes, sir.
You can say it
So
is
there's a participant raising hand. Sorry, you were saying something.
easier to run the country than running a family.
So thank you for enlightening us. My question is, can you share something about the child custody from UCC point of view?
Yes. Earlier, see, child custody is a major contentious issue in all marriage and divorce cases. So generally, even the case law, you will see that up to the age of 5, generally the custody of child is given to mother. And
Yes.
that is now in legislation for under UCC also. So under the age of 5, obviously the custody will go to mother. After that, the say custody may be given as per the decision of the family court to either mother or father. And after 18, the child is, when he or she attains the age of majority, can take his or her own decision whether to live with father or mother. So these are at present the custodial rights. So
Yes.
now it is legislated under the UCC that below 5 years, the mother will have the mother only the mother will have the right of custody, and after 5, it may be given to courts either to mother or father. So there is uniformity in this. Earlier, it was not legislated. So for minor children, or say, or in case of widow or remarriage, because sometimes if a person dies within say 5 years of marriage, then there were widow remarriages also, and we also have widow remarriages act in India. So in
Yes.
such cases, there were two issues. First issue is or first type of dispute is regarding the custody, and second type of dispute is regarding the maintenance and the inheritance. That is the whether the child will get the property of the mother or father. So these are generally the say bones of contention between the spouses in case of marriage and divorce cases. So UCC is going to change that also. Thank you.
Okay, sir. And my next question is, I think, will there be family courts in Uttarakhand because UCC is implemented?
Yes, family courts are there. In fact, family courts are
It
there, and
it will be continued
they are
as it is.
as it is. The only thing is, earlier they were going as per the family laws of different communities. now they will have to take the decisions according to these laws, because see, there is also provision of I'll directly go to what say the end of this say this one. See, what are the provisions that it repeals? So it repeals certain older, and
Yes.
whether the provision
Yes.
whenever the provisions are inconsistent, so these inconsistent provisions will be
Okay.
repealed. In such cases, the family courts will of course implement these laws also. UCC, they will have to implement and take decisions as per UCC since the date of effect, not the older laws, as far as they are inconsistent.
Thank you.
Yes, ma'am. I would want to know if in the UCC, adopted child in case of Christian marriage will be entitled to the property, ancestral property of the parents, of one of the parents.
Yes, in adoption also, earlier see we have this Hindu this guardianship and wards act, even for adoption is there in the Hindu Code Bill of 1955 and 1956. So now in UCC, this as far as the adoption cases are concerned, so because the definition of family include itself says that family is say people who are who are related by birth, marriage, or adoption. So adoption is there, and adopted children have the same rights. Even under UCC, even the children born within wedlock and out of wedlock have got recognition, and even the children with born out of live-in relationship have got the same rights. So all these children are considered equal, and they have equal rights for property as well as for maintenance. That is there.
Even in the Christian marriage.
Yes, even in case of Christian marriage or
Christian
any
marriage.
say yes, regardless of their communities. Yes.
Christian personal act. Okay. Okay. Thank you,
Yes, yes.
sir.
Thank you.
So the next question is, what according to you are the loopholes in the law?
Loopholes is, see, there is some criticism, as I have told, that these scheduled tribes have been kept outside its purview, and some people attribute it as it is, say, due to political reasons or due to vote bank politics. So that is the major allegation against this. That if it is uniform, then why these scheduled tribes have been kept out of purview of this? But they have taken the shelter of this constitution rights, that in part 21 of the constitution, since they have been given special status, and therefore in Uttarakhand they have not been applied to scheduled tribes, and even in India it may not apply to scheduled tribes. So that is the we can say main drawback or the adverse criticism of this law.
So the next question, what are the requisites for registering a live-in relationship?
Yes, live-in relations is very interesting question. I will go to part 4 of this. I'm opening this full act. See, as far as live-in relationship is there is a separate chapter that is provided in this Uniform Civil Code. As you can see, I'm displaying it on my this. See, let us see the structure of this act. First, we have this chapter. The first part is related to preliminary. Then we have part 1, that is marriage and divorce. Then there are separate chapters in that, that is conditions for solemnizing contracting marriage. Chapter 2 is registration of marriage and divorce. Then we have chapter 3 for judicial separation. There is nullity of marriage and divorce. Chapter 5 is incidental proceedings. Then we have chapter 6, that is jurisdiction and procedure. Then we have chapter 7, supplemental provisions. Then part 2 is relating to succession and inheritance. So there is intestate succession. There is chapter 1 for that. And you will see that some of the provisions are directly, we can say, have been borrowed from Indian succession at 1925. Then chapter 2 is testament and testamentary succession. Then we have chapter 3. I will come into living in relationship also one by one, because that I have to answer that question also. I remember that. Chapter 3 is protection of estate of deceased. Then chapter 4 is representative title to estate of deceased on succession. Then probate, letters of administration and administration of assets of deceased. That is chapter 5. And then we have chapter 6. So chapter 6 is sorry. Yes, it is. I'm moving to that. Chapter 6 is regarding succession certificates. That is who will inherit what property of the deceased person. So there are succession certificates. Then we have chapter 7, that is miscellaneous. Part 3, sorry, it's not part 4, it's part 3. This is relating to live-in relationships. Now this live-in part 4 is also there, but that is miscellaneous. So live-in relationship in India, in Uttarakhand, there are these these sections. First is submission of statement by partners to a live-in relationship. Then there is section 379 of UCC Uttarakhand says children of live-in relationship. Then when live-in relationships not to be registered, then procedure for registration of live-in relationships. Registration under this part only is for record. Then empowerment of registrar under this part and maintenance of registers, that is registers of live-in relationship. Submission of statement of termination of live-in relationship. Then duties of registrar, that is registrar of marriages. Then notice for registration of live-in relationship, offences and punishment. Then maintenance and power to make rules. That is from we see that section 378 to 379, 389 of Uttarakhand UCC Act relate to live-in relationship. Lastly, we have part 4, that is miscellaneous. So there is repeal and savings, and that is very interesting part because how it is going to affect the existing laws. So I would like to go into detail of that. See, there are 7 schedules also to this act. So these schedules are there. I will read this. If we see schedule 1, it just looks like our Hindu marriage act schedule. That is who gets what percent. Firstly, there is list of prohibited relationships, Sagotra marriage as we call it in Hindu marriage act. So what are the prohibited relationships within which marriage cannot be solemnized or marriage cannot be done? This is there in section 31D of this UCC. So there is list 1, Sagotra relationships or relatives who can't marry. Secondly, list of heirs for succession. That is, this is as per the Hindu marriage act schedule. So this is as per section 49 of the UCC. This is schedule 2. Schedule 3 is there. That is section 265(2). That is form of certificate. Schedule 4 is form of caveat. This is under section 275 subsection 4. Then there is form of probate. That is section 280. You will see that some of the provisions are also related to our Indian Succession Act of 1925. Then there is section schedule 6. That is section 281. This is form of letters of administration. And lastly, the 7th schedule is about section 365 forms of certificate and extended certificate. So these 7 schedules are there. Coming to the repeal and savings, how it is going to affect so many older laws. So that is clarified in this last section, which we call as the miscellaneous. So I would read out that part 4. It says that subject to the provisions of section 2 of this code, any law, statutory or otherwise, practice, custom or usage in force in the state immediately before the commencement of this code relating to the matters covered by this code shall cease to have effect within the territory of the state insofar as they are inconsistent with any of the provisions contained in this code. So any inconsistent provision cease to have effect in Uttarakhand, and that's why the bill was sent to President of India, because it affects the central laws also. Secondly, nothing contained in this code shall affect any right, responsibility or obligation accrued or proceedings initiated under any law for the timing in force prior to the commencement of this code relating to the matters covered by this code. Such proceedings shall continue as per the law, that is statutory or otherwise, practice, custom or usage existing on the date of commencement of this code. That is saving clause. What happens to the already court cases going on? That is clarified in subsection 2 of section 390, that they would go on as per the older laws applicable. Subsection 3 says that for removal of doubts, the Uttarakhand Compulsory Registration of Marriage Act 2010, that is Uttarakhand Act number 19 of 2000, is hereby repealed because it is already covered in this. And their power to make rules, because we have seen Shatrughan Singh Committee also made the rules. So the state government may by notification in the Uttarakhand Gazette make rules for carrying out the purposes of this code. It is very wide rules given in 4 parts. I will not go into details of that, but I have already downloaded. So these are available on this UCC website. Then without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters, namely facilitating the processes by putting in place electronic and digital systems. So we see already the portal has been opened in Uttarakhand for online procedures, allowing parties to make submissions and applications through designated web portals. So that has already been there. And that's why we see there is, say, protest by advocates of Uttarakhand today on the Valentine's Day in Uttarakhand. Then they are going to say protest against this, and facilitation and encouragement, because maybe some people say that it is going to adversely affect the business or practice of advocates in Uttarakhand. Facilitation and encouragement of registration of marriages, including compulsory registration for availing benefits under government-sponsored welfare schemes. So for these welfare schemes also rules may be made by the state government, which have already been made in Uttarakhand, and any other matter which is required to be or may be prescribed or provided for by rules. And then there is power to remove difficulties. That is there. That is the last section of this act. So if there are any difficulties, whenever any new law is enacted, so within 2 years, these difficulties can be removed by an act. After 2 years, the matter has to be taken to the parliament or the state assembly, as the case may be. So if any difficulty arises in giving effect to the provisions of this code, the state government may by order establish, publish in the official gazette, make such provisions not inconsistent with the provisions of this code as appear to it to be necessary or expedient for removing the difficulty, provided that no such order shall be made after the expiry of a period of 2 years from the commencement of this code. And subsection 2 says that every order made under this section shall, as soon as may be after it is made, be laid before the state legislative assembly. So I hope I have already answered the question about this live-in relationships, and maybe if someone is interested, they can go through part 3 of this very long act. Thank you.
Yes, sir. Sir, participants are asking if you'll share the PowerPoint.
Sure,
They're
madam.
asking for the PowerPoint.
I will share. Even this recording can be shared by you. When you ask for consent, I will give consent for sharing my recording also, as well as you can
Yes,
share
sir.
both these. I'll send you PPT files.
And
Because
sir,
PDF
any
files
other
are very-
reports you mentioned? Can you repeat the reports that the participants can refer to?
reports, references.
Yes, sir.
I would go to my references. So I have already named those earlier presentation. The second presentation was of 2023. Another one I had prepared today itself. So these are the references. Firstly, rather than bill, now you can refer to Uniform Civil Code of Uttarakhand. Next, if you want to go into detailed history, you please go to Uniform Civil Code Wikipedia page. Wikipedia has got all the history of this UCC in India. Okay. Then UCC Uttarakhand official portal is there. Then there are some recent articles that I have told. Firstly, Uniform Civil Code will work in how it will work in Uttarakhand. There is live law article, that is Uttarakhand rolls out Uniform Civil Code, becomes first state to do so. And DD News article, that is Uttarakhand becomes first state to implement Uniform Civil Code. As far as the Law Commission of India reports are there, so you can refer to all the reports that are there. There are so many reports, but they there are more than 200 reports, and all are public on the Law Commission of India website. Out of that, you will have to search for the reports, say smaller and bigger, and they are available in English. Some of them are available in Hindi also. And you can download and see those reports, older as well as news, because some of these provisions have been implemented, some of these provisions have been rejected by the parliament, some of them have not been implemented, but now they will be implemented through UCC. So in parliament also, 2 bills were passed. I think I have skipped that part. So maybe yes. Yes. So if we go to the history, then we see that through say past 100 or more than 150 years, some of these things have been there in British India also, and maybe you can go through that history on the Wikipedia page.
Okay, sir. So we are done with the queries. Can we end the session, sir?
Yes. So
Okay.
there are no.
So thank you so
no more.
much for extensively giving us an understanding of the act. It was a really enlightening webinar. Thank you so much, sir.
Thank you, madam. Thank you. Thanks for inviting me, and thank you for giving me an opportunity to make this presentation. Thank you. Thanks to all the
Thank you, sir.
participants also.
Okay. Bye, sir.